You sued your doctor for medical malpractice, and now your attorney tells you that you have to appear for a deposition and answer questions by the defense. You turn around and say, there is no chance in hell that I'm ever going to answer questions by the defense attorneys in this case. You can go tell them to take a hike. Can you do that? Will you do that? Will it affect your case if you do that? Would you like to learn the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so here's the scenario. You sued your doctor claiming that he was careless and caused you significant harm and injury. Your doctor denies all of your allegations. During the course of your lawsuit, your attorney tells you that you are now going to have to appear for a PreTrial deposition, which is a question and answer session that in pre-COVID times would take place in his office. Now, during COVID times, this takes place typically on a Zoom video call. Your attorney tells you that he has to prepare you for the questioning, which will take place a few days later. And you turn around and say, listen, I'm too busy. I am not participating in any question and answer session known as a deposition or an examination before trial. Tell these defense lawyers to go take a hike. There's no chance in hell I'm participating in that. They want to know anything, they can ask you questions, they can look at my medical records. I am not showing up for a deposition. I've already wasted so much time dealing with my injuries. I now have to suffer. I now have all these problems and limitations and disabilities, all because this doctor was careless. So I'm not wasting any more of my life to spend on this case and answering these questions. So the more important question I have for you is, can you do that? Can you tell your attorney that you are not showing up for a deposition to answer questions by the defense attorney? The answer in New York is, no, you can't. Once you have gone ahead and sued a doctor or hospital in a medical malpractice case, now your life, your medical condition becomes an open book. How does the defense know that what you are really claiming is true? How do they know what really happened if they don't have a chance to question you? The defense attorneys have an opportunity during the course of a deposition to ask you questions, to learn from you in your own words exactly what happened to you, exactly what your interaction was at various times with the doctor whom you have sued. They are entitled and permitted to ask you those questions. They are entitled to learn what problems you had as a result of whatever treatment or non-treatment the doctor provided to you. And if you fail to provide them this information, now you've got a problem, my friend. Why? Because without that information, without that confirmation from you directly, the defense is now at a distinct disadvantage. They don't know whether the information you have claimed in your case is actually true. They don't know whether or not the problems and the injuries you have today are really disabling. All they have is a two-dimensional picture based upon the records that we have provided to them about what's going on with you. And that's not a real true picture. It doesn't give the defense a real understanding of exactly how your injuries have affected you on a daily basis. How have they affected your family life? How have they affected your work life? How have they affected every aspect of what you do with your family, with your kids, with your spouse? They won't know that unless they actually have an opportunity to go ahead and question you. If you deprive them of that opportunity, they are now at a significant disadvantage. And in that instance, if you turn around and actively say, I am not showing up for a deposition, I'm not taking any more time out of my life to go ahead and answer these questions, you are preventing them from learning more details and information about your case that actually might help you in the long run. Because if your injuries are as significant as you claim, and if the liability is so clear-cut that anybody learning about this information would have no doubt whatsoever that the doctor was careless, then now it is possible that your testimony will help settle your case at a much quicker pace. But if you refuse to answer these questions, now the defense is at a loss. And the only remedy they have at that point is to go into court and to tell the judge, Judge, we're entitled to have this information, to learn this information directly from the plaintiff himself, the person who is bringing the lawsuit. This person is refusing to show up and answer our questions. How can we proceed? We can't proceed, so therefore we want you to punish this person, and we want you to prevent them from being able to put in any proof at all later on down the road. And you know what the judge is going to do? The judge is going to agree. He may give you one or two other opportunities to show up for a deposition, but in all likelihood, because of your expressed outrage that you have to spend additional time doing this, There's no way you are going to change your mind and change your opinion. And because of that, now the judge will have no choice but to agree with the defense attorneys and turn around and actually not sanction you, but preclude you, prevent you from actually putting in proof, putting in evidence to show that the doctor was careless, putting in proof to show that the doctor's carelessness was a cause of your injury and that your injuries are significant or permanent. And once that happens, your case is basically over. Without being able to go ahead and put in proof of anything in your case, now you've basically shot yourself in the foot to spite yourself, and your case is really over. You can never get to trial. The defense will turn around before you ever get to trial and say, Judge, you precluded this patient, this plaintiff, from putting in any proof because he failed to show up for his deposition. And now he wants to go to trial because he can't put in any proof. There's no possible way he can go to trial. And the judge will agree and throw your case out and dismiss it. So don't think for a second that just because you are being inconvenienced and just because you are outraged by what your doctor did, that now you can turn around and decide on your own. Decide, I'm not showing up for a deposition for the following reasons. I don't care what happened. I am not answering questions by the defense attorney because of anything that the doctor did. Well, guess what? That does you no good. If you decided to bring a lawsuit seeking money as a form of compensation for all the harms and losses and damages that you incurred because of this careless doctor, guess what? If you fail to comply with court rules that say you have to show up for your deposition, your case isn't going anywhere. So why do I share this quick information with you? I share it with you just to give you an understanding of what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. You and I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit, but are still thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.